Continue to enjoy your lunch. I am going to introduce our lunchtime keynote speaker, David Lawrence. He's going to share some thoughts and insights with us while we continue to enjoy lunch, and we'll go from there. David Lawrence is the Policy Director for the Antitrust Division of the United States Department of Justice. He oversees policy development at the division and supervises appellate, competition policy, and advocacy and international sections. Mr. Lawrence has served at the Antitrust Division since 2011 in a variety of roles, including as Chief of the Competition Policy and Advocacy Section, as counsel to the Assistant Attorney General, and as the lead of several major civil merger and conduct enforcement matters. He was a law clerk on the Second Circuit, Court of Appeals for the Second Circuit, Judge Wilfred Feinberg, and to Judge Richard Holwell, of the United States District Court for the Southern District of New York. He earned his JD from New York University and his BS in physics from the University of Massachusetts. So we're really grateful to have you here and look forward to your remarks.
Great, thank you. Appreciate the invitation and the introduction from Clark. I have to say I continue to pinch myself that we're able to meet in windowless buildings like this together. You know, it was a long pandemic and I attended probably a dozen virtual conferences. I like them, they're really easy to plan, right? I appreciate we have a digital audience today. It's a lot easier to get more people in. But there's also those downsides. I think the cold edges of debate and disagreement, they feel even colder on a Zoom screen. And you know, we still don't have the monitors that convey empathy, right? Working with each other. And so the disagreements are coming through, but the spirit of collaboration doesn't, right? So I will say it's possible the metaverse is going to solve that, right? So Clark, you start working on the metaverse lunch for when we meet in one of those rooms. I have to say one of the lessons of the pandemic for me has been we need to find common ground and use the warmth of connection and dialogue to help reach for it. And so that's what I want to talk about today. We have a lot of debates in antitrust, but I think there's a lot of common ground. And what's remarkable is there's more and more emerging common ground in many places and areas that is old ground as well. And so I'd like to walk through some of that. I do so because we're at a very interesting moment standing here today. The House of Representatives just passed, with a strong bipartisan majority, significant antitrust reform legislation. There's other legislation being developed, but for any watcher of American politics today, seeing a bipartisan vote on the House floor was a pretty remarkable moment. And I think we've learned that there's a strong majority in Congress and in the country that supports more aggressive and effective antitrust enforcement. Where does this come from? I think it comes from concern in our citizenry about the rise in corporate power in our democracy and our economy. At the Antitrust Division, you know, we're technical, so we see this in technical ways. There's a rise in price cost markups. There's a decrease in new firm formation. And there are rising indicators of concentration, along with a robust sort of debate about what all of that means. But when we hear from people in the American public, we hear about a group of citizens who are concerned about the direct impacts of too little competition. And so I think this attention we see in Congress and in the media to the state of competition, it's actually reacting to a sort of very, a very ingrained popular interest that arises from personal experience. And you know, I hear this myself, you know, I have family members, we all do, who like used to see what we do as a very technical corner of the world. And now like you go home to a dinner and they say, what's going on with the power that certain firms have in our economy, right? They're seeing this in subtle but important ways every day. They have very few choices with how to connect with loved ones. They see their private data extracted. They're not sure that people are competing. So Congress is responding. The department is doing its best to respond. And we're hoping to see reforms passed into law like what I just mentioned. But merger filing fee reform, that's not the only area of common ground, at least as I see it. I've observed a lot of new consensus emerging, and I'd like to talk today about just 4 areas. I'll go through them one at a time for you. So first, and this is a big change, but a return, that antitrust supports not only our welfare as consumers, but our liberty as Americans. Second, that enforcers at the agencies, we need to stop trying to get it wrong on purpose and just try to get it right in every case. Third, that the law forbids mergers that pose incipient threats to competition. And fourth, that new market realities in the digital economy, what we've been talking about today, they increase the urgency of action and they demand that we adapt and evolve our analysis. So let me go to that first one. This is an area really across the country of emerging consensus and renewed consensus. Antitrust protects our welfare as buyers and sellers, but it also protects our liberty as Americans. Not a new concept, right? This dates all the way back at least as far as the Boston Tea Party, when they dumped that tea in the harbor because the colonists were rejecting the British Crown's imposition of a monopoly. Even though, as a technical matter, the price of that tea was going to be lower than the other tea available. And it was present, of course, at the creation of the Sherman Act in 1890. You all know, I'm sure, that Senator Sherman said, monopoly is a kingly prerogative, inconsistent with our form of government. And then the Supreme Court, 1951, Northern Pacific, said that the Sherman Act is a comprehensive charter of economic liberty. That's a quote. You often hear that quote. And then in the same paragraph goes on to say, at the same time that it supports our welfare, it, quote, provides an environment conducive to the preservation of our democratic, political, and social institutions. That's the Supreme Court in 1951. It repeats that exact line in 1984 in Board of Regents. We're hearing this sentiment again from a range of sources. I mentioned what's going on the Hill. I won't put names on members of Congress, but you can guess who said what. So one member of Congress said, there's a, quote, real threat when a monopoly controls information in a democracy, and competition is the answer. Another said we need to break the political influence of market-dominant companies. And yet a third told the Senate floor that concentrated economic power can be just as dangerous as concentrated political power. So you can guess who those quotes are from, but I'm sure it would not surprise you sitting here. They're from all across the aisle and from very diverse stakeholders. Even Justice Clarence Thomas in the Supreme Court recently lamented, quote, unprecedented concentrated control of speech in the hands of a few private parties. Why are these old ideas common ground again? Because they are at the heart of our shared constitutional structure. When I was in grade school civics, I learned that we lived in a capitalist democracy. Remember the teacher working it through on the board. I'm sure most of us did. But until I studied antitrust, I never understood why we put those words together. I remember going home and asking my parents, like, why aren't they a democracy? Well, they're communist. Okay, well, do they vote? Well, no, they're not capitalist. What is it those words have in common? It's the foundational premise, the liberty of the individual. That is why the words capitalism and democracy go together. They both are premised on and demand the individual's liberty, the individual's choice, the individual's opportunity. As antitrust enforcers, and in the Congress when they draft antitrust legislation, they're helping prevent our political economy from descending into oligarchy. And they're guaranteeing to the people, as the Constitution requires, a Republican form of government. Okay, but what does that mean for antitrust enforcement day in and day out for particular cases? It means we must aggressively enforce the antitrust laws as we find them to ensure they continue to provide an environment conducive to the preservation of our democratic political institutions. It's actually why I think my next point is so important. The second area of emerging consensus is that enforcers need to stop trying to get it wrong on purpose. That sounds silly, but that's actually what we've often been doing and been told to do under the error cost analysis that bloomed in the 1980s as the prevailing argument, a powerful argument in its application for under-enforcing the law. That error cost, an error as it's used most prominently traces to Judge Easterbrook's article in 1984 on the limits of antitrust. As the argument goes, you're probably familiar, monopoly is self-destructive. And so, quote, judicial errors that tolerate baleful practices are self-correcting, while erroneous condemnations are not. That assumption's been used to justify under-enforcement in a wide range of circumstances. We see it in Trinco and other cases. We saw it in the withdrawn Section 2 report from the agencies. I mean, it's something I at least heard in my Antitrust 101 as to why we should be extra cautious. I believe this error cost error actually undergirds the excessive focus on predictive certainty that has emerged in merger review and led us to ignore the prophylactic role of the Clayton Act and the Seller-Kefauver Anti-Merger Act. I'll come back to that with my third note. And I do say there is an emerging consensus that this error cost framework was wrong. Professors Herbert Hovenkamp and Jonathan Baker, writing separately, they've both unpacked the history of this unfortunate error in a lot greater detail than I will, but I'll just offer up a few things that are very important. First, this assumption that markets are self-correcting. I think no candid and honest viewer of today's economy would agree that that's true. Markets do not always self-correct because entry barriers can be quite real. They may be exclusionary, they may be regulatory, or they may be natural features of markets. Just to run through those, exclusionary and regulatory barriers to entry, they arise from the fact that monopoly rents, as it turns out, are rather profitable. So a portion of those rents can be spent to undermine competitors or pay off third parties, either of which creates exclusionary barriers to entry. Meanwhile, regulatory barriers to entry, well, they may exist when a monopoly arises, but they can also be acquired by spending monopoly rents to influence regulatory processes. In fact, going back to Senator Sherman in 1890, that recognition was one of the core reasons for the creation of the Sherman Act in the first place. We're also seeing how natural characteristics of markets can create significant entry barriers. In the modern economy, network effects are incredibly common. A tremendous amount of ink has been flipped on that, has been spilled on that, but it flips Judge Easterbrook's analysis on its head. When markets have natural tendencies towards tipping, if anything, error cost analysis would lead us to over-enforce rather than under-enforce. Not that that's what I'm suggesting. And the other side of the coin, the idea that judicial errors can't be corrected, that's wrong as well. Changing circumstances can reveal the error in a judicial antitrust framework or create context when it's not applicable. The idea that the generation of GTE Sylvania and Legion would rest its paradigm on the idea that judicial errors can't be corrected fails to understand the nature of the judiciary. And we saw this even last year, the Alston opinion, a unanimous court. The Supreme Court said, quote, judges must be open to clarifying and reconsidering their decrees in light of changing market realities. And if the market realities change, so may the legal analysis. There's ample room for correcting judicial errors, whether they cause over-enforcement or, as is probably often the case, under-enforcement. And finally, going back to my first point, the error cost framework failed to recognize the systemic benefits to our democracy and our economic liberty that flow from keeping power in check. When the theory was drawn up, an important part of the equation was just left off the whiteboard. The systemic benefits of constraining power always augur towards greater enforcement. So In my view, getting it wrong on purpose through intentional under-enforcement is failing to vindicate the values of the antitrust regime. And as I said, it's not just my view. I'm hearing this more and more throughout the community. I think that the arguments here are strong, and that the new emerging antitrust consensus should be, that we ought to try to get it right in individual cases. We should use the best tools we have available to get the best answers. Whether that means enforcement or non-enforcement, we shouldn't put a thumb on the scale. That has implications for my third point, so merger enforcement. I think there's an emerging consensus that the Clayton Act and the Seller-Kefauver Act demand the prohibition of mergers that may lessen competition when those harms are in their incipiency. Again, not a novel point. I just used some pretty old phrasing. The statute itself says it prohibits mergers whose effect may be to substantially lessen competition. But I'm seeing that it's new again. We received over 5,000 comments in our merger guidelines review. And one of the most consistent threads was an exhortation to take incipiency seriously in merger review. Brown Shoe, of course, sets forth this incipiency framework for merger review. There, the Supreme Court offered what is still today the controlling interpretation of Section 7 of the Clayton Act, using traditional tools of statutory interpretation. It evaluated the text of the statute, the legislative history, and it pronounced that the, quote, keystone of Congress's solution to the rising tide of economic concentration was its provision of authority for arresting mergers at a time when the trend towards a lessening of competition was in its incipiency. Yet I think a peculiar application of the error cost framework, which was about monopolies, has been a creeping trend away from an incipiency standard towards something like a rule of reason framework that requires demonstrated near certain effects as a necessary basis to challenge a merger, rather than a risk that there may be those effects. Now, I know there are probably some people in this audience or reading something like this that think, well, but Brown Shoe, that's not the standard. It's still very much good law. In fact, the last time the Supreme Court discussed the substantive standard for Section 7 was in California v. American Stores. It quotes Brown Shoe for the proposition that Section 7 creates a, quote, relatively expansive definition of antitrust liability, that to show that a merger is unlawful, a plaintiff need only prove that its effect may be substantially less than competition. And Justice Stevens, writing for the unanimous court, I guess in 1990, they didn't just have to hit Control-I. He italicized the words may be and put that emphasis added in the footnote. These words matter. Now, I don't suggest that the judicial canvas is blank, whether since Brown Shoe or since California v. American Stores. We're all familiar with, of course, General Dynamics, and there's Baker Hughes, Hospital Corp., which either directly or in dicta discuss means of rebutting a risk of harm. But the idea that a rebuttal step being acknowledged in the courts somehow raised the bar for a prima facie case and for establishing a risk of harm, that's a misreading of the law. The incipiency standard is going to continue to be important as we consider markets where firms already have a lot of market power. This is something we're dealing with and talking about all the time. So in the 2010 merger guidelines, it references a concern with mergers whose effect may be to entrench market power. There may be diverse ways that a merger could entrench very, very powerful positions without us being able to specify with precision exactly how that powerful position will be eroded. We may only be able to identify that the powerful position is less threatened than it was before the merger. In the guidelines comments, a wide range of stakeholders have called on us to reinvigorate merger enforcement in these kinds of markets already dominated by powerful players. So to do so more effectively and consistently with the law as we find it, we're looking very closely at how we can better respect this incipiency framework in evaluating the risk that market power will be preserved. Now, your lunch is probably just settling, so I'm on my fourth and final entry here. There's now a widespread concern, and the seminars are populating wildly, that we ought to be concerned about digital markets, that something's going on. On the bipartisan consensus point of view, my friend and former colleague Roger Alford has a recent paper in the Emory Law Journal that's worth reading, titled "The Bipartisan Consensus in Big Tech." It goes in much greater detail to these issues than I can here. I believe that the power in the digital economy has captivated the world's attention precisely because of the unique threats it poses to our liberty. So at the opening of today's events, David Higbee mentioned the analogy of actually my very expensive new Apple Watch to the band worn by a prisoner to track their data and information. He set it up perfectly. As opposed to market power in widgets, the digital age is not only characterized by the presence of power, but by means of its exploitation that are more threatening to our individual freedoms than in any of the traditional markets we're used to. That is why we see this popular concern. It's more than an extra $1 on a pair of tires. It's about the control that the companies have over our lives. And those attributes of digital markets, they're contributing to the preservation of power in critical, new, and important ways. Collaborative platforms, as so many are, connect not only with millions of users, but with hundreds of thousands of businesses. They're built on interconnection. Those ankle bracelets are not only on each of us, but on every potential competitor. They're on participants in adjacent businesses. They're on enormous swaths of an ecosystem. When a single firm enjoys that level of power, information, and control over that large a portion of the economy around them, they have new opportunities to influence the development of business toward the preservation of that power. That doesn't mean, of course, the way they use it is always bad. In fact, it's been profoundly good. I love my watch. But it does mean we need to take very seriously that there are new kinds of threats. We need to ensure that we're adapting our enforcement and the law to deal with the new situations we face. Just a few implications for competition policy. Frameworks for assessing interconnection or refusal to deal policy have to be viewed through the lens of fundamentally collaborative platforms. Those are different underlying market dynamics. You look at cases like Trinco or Linkline, they're focused on novel, bespoke, and new competitor access to physical infrastructure solely owned. Very, very poor corollaries for thinking through the means and manner of access to digital public squares that are inherently massively connected. The presence and power of the existing barriers to entry with the interconnection across would-be rivals and ecosystems creates significant dependence on the platform and ability to extend market power. So that's my fourth item. Probably slightly less in this audience of a consensus yet, but I believe we are moving towards better understanding. And actually, that's where I want to conclude. Every one of us in the antitrust community has the good fortune to be part of actually an incredible moment in America. I recently went to the bookstore. I was going to take a long flight. And you're looking for books that pique your interest. I found at least a half a dozen books about the work we do in the antitrust community. They're written from all kinds of perspectives and viewpoints, some of them completely from outside, some of them, in my view, better than others, of course. But they share many of the same concerns, and at bottom, they share an interest and a recognition of a popular interest that we're in a moment of reassessing. Because of our background and expertise, we have the good fortune to play a unique role in that public conversation. I believe it's incumbent upon us to hear the concerns expressed around our country and to advance our analytical tools to reflect the same market realities that gave rise to them. So debates like we're having today and like we're having at so many seminars these days are how we will build the new antitrust consensus. I think that's an incredibly exciting thing for us to be doing together. And I really look forward to all the discussions to come.